Good afternoon. This is the Miller Johnson Benefits Lunch Break webinar series for November 15th. I'm Frank Barradin, and I'm going to be giving you today an end-of-the-year retirement plan checklist. We always schedule this kind of early in the year to be a good time to go over things that you want to be aware of and consider at the end of the year. And when we schedule it, we never quite know what there will be. In some years, there's far more that you need to pay attention to at the end of the year than others. And this is one of those years where there's a few things, but not an overwhelming amount, which is good. Such a beautiful day. And hopefully this will not take too long and you'll be able to get some of your day back and hopefully get outside and enjoy this weather because we know what's coming soon. First thing I want to let you know is that our next webinar series presentation will be on December 20th at noon, and it is the Ask a Benefits Attorney presentation. So if you have any questions about anything related to benefits, and that includes health and welfare, retirement, deferred compensation, even if you go outside that, we'll try to answer it if we can. So submit your questions by Friday, December 15th, and we will do our best at that presentation to answer anything that you have related to benefits or something that's even remotely related to benefits. We'll give a try to answer. Also, if you have any other topics you'd like to see us present on, then please submit those and we will try to make them the topic of a future presentation. So today's discussion is going to start with the new safe harbor deadlines. Now, these are not so new because last year they were first implemented, but since the old rules were in effect for like 20 years, I figured it was good to remind everybody that we are now using the new rules. And so you have until December 1st of this year to choose to use the 3% non-elective contribution if you decide to, you're not passing ADP testing on a projected basis, or you just decide you don't want to run it. You can commit to use the 3% non-elective contribution, and you have until December 1 of this year to make that election for this year. If you're using the safe harbor matching contribution, you have until December 1 this year to make that election for 2024, since you have to provide advance notice of participants so they understand they're going to get the safe harbor matching contribution and make their elections for next year. You still do have an option of making the safe harbor election for 2022 by December 31 of 2023 if you were to use the 4% non-elective safe harbor contribution. And then obviously you have until the end of 24 to do that for 2023 if you wanted to do so or had a reason, found out after the fact that you were failing the testing that you thought had been passing, maybe there'd been a mistake made. You still have time all the way to the end of the following year to commit to make that 4% safe harbor non-elective contribution. So the end of the year, what you need to do certainly is verify that safe harbor notices have gone out. Any automatic enrollment notices have gone out for next year, and QDIA notices, anything else have been distributed. And so that's all coming up here in the next 2 weeks, basically. You need to make sure that that gets done. Okay, next thing is 2024 dollar limits. Probably everybody's seen this. This is one of the downsides to when we have low inflation or lower inflation, I should say. I mean, we went several years there where the limits didn't even change because there was no inflation. But last year we had that big bump. This year we go from 22.5 to 23 on the 401k, 403b deferral limits. Compensation goes from 330,000 to 345. Defined contribution, total contributions goes from 66,000 to 69, and who's a highly compensated employee goes from 150,000 to 155,000. And remember, that's always looking back to the prior year. So you may want to consider structuring somebody's compensation who may be on the bubble If you can keep them below that limit, then you could always provide them a much larger retirement plan contribution to, provide them with the same total compensation and much more of it in deferred compensation. Once they become a highly compensated employee, you lose that ability. You might still be able to contribute more for them, but it makes it much more difficult when they're a highly compensated employee. Okay, as far as required amendments for 2023 on your retirement plans, the great thing is there aren't any for qualified retirement plans unless you have implemented a discretionary provision in 2023. And keep in mind that these discretionary provisions are generally not things that are Secure 2.0 Act related. They are, let's just say you changed your eligibility provisions, or you changed the amount of a contribution, or you changed something like that that's unrelated to these recent law changes. Then you have to adopt that amendment by the end of this year. But all of the other stuff, all these optional things under Secure 2.0, for example, even if you implement them, you don't have to have the amendment adopted until 2025. So 2023 is a nice year end from the standpoint of not having to adopt, discretionary amendments for particular regulations and things. Probably the single biggest thing that most employers need to pay attention to for year end here is the new long-term part-time employee rules, which become effective January 1, 2024, or at least first day of the 2024 plan year. And this is part of Secure Act 1.0, the original one. And it says that if any participant or any employee has worked 3 consecutive years with 500 hours or more, they have to be allowed to contribute as of the first day of the 2024 plan year. Now, if your plan has no waiting period or has an elapsed time waiting period that obviously wouldn't be more than 1 year, you don't have to worry about this. But if you've got the standard 1 year with 1,000 hours, and you've got employees that work fewer than 1,000 hours, or you have immediate entry for full-time employees, but you have a special provision that requires 1 year, 1,000 hours for part-time, temporary, those kinds of employees, you need to be concerned about this, because if you fail to enroll them as of January 1, then you will have to make a corrective contribution on their behalf when you discover it, or the IRS discovers it, and that is based on the average deferrals that is being made by those participants who were given the right to contribute. So that could be significant. So this is very important to pay attention to. In many cases, I'm recommending that employers just consider dropping their waiting period altogether for making pay deferral contributions, because the rules have made the problems that existed in the past with doing that, things like the plan was top heavy, things like having to make employer contributions for these individuals. The rules have clarified that you don't have to do any of those things. You don't have to include them in testing or anything if you allow them to contribute. So that's certainly something to consider if you're currently excluding those employees, and especially if you don't want to have to track hours for, if you have a number of employees who typically work fewer than 1,000 hours a year. Next thing I want to cover briefly, Department of Labor proposed fiduciary rules. So this was just issued on Halloween, October 31st of this year. And you may be thinking to yourself, well, proposed, haven't these been around for like 10 years? And yes, they have. They've gone back and forth with different administrations, making the rules strict, then, making them much more liberal. Then now we're back to strict. And there's been court cases and things that have slowed down the implementation of these rules. But I think what they've come out with now does follow the rules that they needed to follow in order to make these effective. So they're not effective yet, and they're likely to be effective sometime next year, because right now there's a comment period, and then there's a notice period and a comment period, and then they will issue the final regulations. So likely sometime next year. And it basically provides that all rollover advice is considered fiduciary advice. So anybody who is going to provide a recommendation for somebody to make a rollover out of a qualified plan into an IRA or from one plan to another, that's going to be a prohibited transaction unless they meet the criteria set forth in this prohibited transaction exemption. They have to acknowledge they're a fiduciary. They have to disclose in writing scope of the relationship, any conflicts of interest, and they have to provide written disclosures of the basis for their recommendation. So in a lot of cases, this is a very good thing because it's going to cut down on a lot of the people out there that right now are able to recommend that people roll their money out of the plan, which in many cases the plan has low fees, has good investment options and things, and into an IRA or an annuity that have much higher fees. The big difference here that this rule has that the prior ones didn't is there used to be really an exception for one-time rollover advice. This is a client, say, that comes to an advisor who's never had any prior relationship with them, and they're basically just like almost a sales presentation saying, you know, here's our recommendation that you roll over, but you're not our client yet. Well, that's changed under this proposed rule and will be eliminated unless this changes by the time it gets finalized. So those will be considered fiduciary advice decisions and will have to comply. And then the other big exception that exists out there right now is for insurance companies and annuity sales, and that is proposed to be eliminated as well. So you've probably seen lots of ads and things that for those kinds of rollovers, annuity sales, that right now don't have to comply with these rules, but by the middle of next year, they likely will have to, which I think overall is a good thing. The next thing I want to cover quickly are updates on lawsuits for fiduciary breaches. As we know, these have been going on for years, and the big thing has been fees. It's the suits in the past have been all about fees, and most of the big plans now are well aware of that and have significantly reduced their fees, are really looking for revenue sharing, those kinds of hidden fees. And so I think you won't see as many cases on fees against the big providers. There still are many smaller plans that have issues there. Whether they'll get the attention of plaintiffs' attorneys, probably not, but certainly the Department of Labor is aware of them and will be looking at that. But I think the next big area of lawsuits are cybersecurity. And there's several of them out there right now. Couple of examples that I gave here were one where somebody lost $245,000 that somebody stole basically out of their account. Another one was $100,000, and that one was settled. But there's one ongoing that was $400,000, and the TPA who got sued actually countersued the employer for saying that the employer had, lax policies in place about remote work and the use of personal email accounts, and that's how the money was stolen. So it's not just an issue certainly for the record keepers of the TPAs, but also the employers. And one development this year that has certainly made the risk much greater is artificial intelligence. I mean, that is obviously, there's so many great things about that, but it also creates so many more risks. And certainly many providers have used speech recognition as one of the ways to protect against, somebody stealing an individual's account as an identity verification. And AI has shown that it can get around that very easily. So that's really something that employers have to pay a lot of attention to make sure that they don't get sued and their participants are protected. So there's really 5 things that I am advising clients right now to really focus on. Number one is certainly the contract language and participant guarantee language that the record keeper and or TPA are providing. Many of them will say, oh yeah, we provide protection for that. When you look at the fine print, it is usually very, very hollow, especially many of these participant guarantees. They say, oh yeah, we guarantee to make you whole, but we reserve the discretion to decide the amount of it and whether we will reimburse you in our sole discretion. So the participant could have done everything right and they could still decide that they're not going to reimburse it. I get it. They are very concerned about being outsmarted by the bad guys, just like everybody else is. But as far as who needs to be liable here, you need to make sure that it's your record keeper, because the employer doesn't have the expertise to, protect against all of this. So that's number one. Number two, you still need to evaluate the record keeper's procedures and then, make sure they're testing it or you're testing whether to see, they are legitimate and hold up. And then you need to find out what kind of insurance the record keeper and any other providers have. You need to review your own insurance to make sure that it covers it, fiduciary liability, officer and director, something, other kinds of insurance that the employer may have to make sure there's protection. And then finally, and this one is really important, and make sure that participant education is being provided, not only by the employer, hopefully also by the record keeper, about keeping passwords safe, doing other things, two-factor authentication, if that's being used, everything to make sure a participant can't later sue and say, well, if I had been told I had to do all these things, I would have been able to prevent this from happening. I wasn't told, therefore it's the employer's liability. And you can certainly see that possibly happening. Another thing to be aware of right now that has developed this year are these lawsuits challenging employers' discretion as to how they use forfeitures under retirement plans. So many plans, because this language has been approved by the IRS, and so many plans say, we'll decide from year to year how we're going to use forfeitures. We can use them to reduce employer contributions, or we can use them to pay administrative expenses. Well, as you can see, using them to reduce employer contributions is for the benefit of the employer. It reduces their cost. If you use them to pay administrative expenses, that generally benefits the participants whose accounts would otherwise be debited to pay those expenses. So some of the courts have decided that they think that's improper discretion when an employer decides to use them to reduce employer contributions, and that would essentially be a prohibited transaction, and the employer can't do that. So the fairly easy fix, but this will likely require a plan amendment. So this is not a mandatory amendment, but it's one that is definitely recommended, is to specify in the plan how forfeitures are used. That will eliminate this risk. And the plan ideally should state that the forfeitures will be used to reduce the employer contributions. And if no employer contribution is made, then it'll be used to pay plan expenses. That really gives the employer the same flexibility they had before, because it can always still reduce our employer contribution, but we wanted to have this used to pay plan expenses, then the employer can just pay those expenses. So it doesn't take away any flexibility for the employer, but it eliminates this potential risk. It may turn out that these cases get overturned when they get appealed and the employers ended up winning, but the simple solution is always to avoid any lawsuit in the first place, and this is an easy way to do that. The last thing that I'm going to cover here is Secure Act 2.0, and this will be really quick because Secure 2.0 is something that when we scheduled this at the beginning of the year, we thought this would be the bulk of the time that I would spend, because there would be all kinds of guidance that had been issued and we could really get into what you should be doing now. The reality is there's been almost no guidance issued. The mandatory Roth catch-up obviously was delayed for 2 years. That was going to be a big one that everybody was going to have to deal with. because the record keepers couldn't really do it, they extended that for 2 years. So there'll be plenty of time to see if that gets changed, or at least the record keepers to be able to update their systems for when they become effective in 2026. And then they gave some guidance on collecting overpayments and some of the self-correction of errors, but nothing really on all of the optional provisions that are available beginning next year. So certainly be on the lookout. There'll be more guidance issued in 2024. We will definitely cover that when it is issued. For now, the only thing that I definitely recommend that clients adopt is the increase in the cash out limit from $5,000 to $7,000. All of the other provisions, generally, you probably need further guidance to consider implementing, and you can't really even amend for any of those things anyways, because we haven't had regulations. So there's just very little. I think some of the provisions that employers are going to be interested in are like the small $1,000 distribution that can avoid the excise tax for early distribution if employees have emergency situations, possibly the $2,500 emergency fund add-on feature that plans can have. Those are things that I think will likely be popular. Some of the other things I think are probably going to be administratively burdensome and probably won't get a lot of attention. But, I think for now, it's just best to wait on those until we have further guidance. That's all I have today. I thank you for your time, and hopefully you can get out and enjoy the rest of the day as a nice day at some point. And certainly, to the extent you have any questions about this, you can email me or certainly let us know, submit your questions for our December 20th webinar, and we will address it at that time. Thank you very much.